What have we got in this one? 4 calls. 4 calls in about 45 minutes to write after I issue spot for 15 minutes. First call is about reading aloud a newspaper article. Second call is currency. Third call is a statement to an officer. And the fourth call is a shotgun. Those sound like items of evidence, so I suspect this is criminal procedure. The paragraph above those calls says, how should the court rule on Dave's motions? So the motions must be in the hypothetical, probably just above this. So I'm going to look at the paragraph above. And I see that Dave is charged with robbery. He's chosen not to testify at trial, but he wants to be allowed to read aloud a newspaper article. And down in here it says that he has moved to exclude from evidence the money found in the briefcase, that's call 2, the statement to the officer, that's call 3, and the shotgun, that's call 4. This first one is an odd one though. All right, he has chosen not to testify, but he wants to be allowed to read aloud a newspaper article to be selected by the judge without being sworn as a witness or subjected to cross-examination in order to demonstrate that he has no accent. Well, that's not a voice exemplar. That's somebody wanting to essentially be a witness, but not be on the stand and not be under oath and not be cross-examined. That's what call 1 is about. And I know the witness rules. The witness has to be competent, has to take an oath to testify truthfully, and has to be available to be cross-examined. Now, could I make some kind of an argument that this is non-testimonial? Well, you could try that, but it really won't work, because in essence what he's trying to do is, by reading this, to testify that he does not have an accent. And so he's trying to have it both ways. He's trying to be a witness but not be under oath or cross-examined. That's not going to cut it. That's what call 1 is about. I can make that a very short call. So my problems are going to be in call 2, 3, and 4. All right, go up to the facts and let's see what we've got. We have bank robbed at 1 p.m. by a man who brandished a shotgun and spoke with a distinctive accent. There's the accent. That's what Dave does not want the court to hear from him. He wants to demonstrate that he is not the person who brandished the shotgun. So yeah, Dave is the defendant, and that first call is definitely about a testimonial act that he wants to perform in court without being under oath. So let's go on. The teller gave the robber packets of marked currency, which the robber put into a briefcase. Currency is call 2. At 3:30 p.m., the police received a telephone call from an anonymous caller who described a man standing at a particular corner in the downtown business district and said the man was carrying a sawed-off shotgun in a briefcase. When they give you an anonymous caller, that's a fact you use to analyze probable cause, because you know there's a search coming up and you're going to need to analyze whether this is a search incident to lawful arrest. In other words, was there probable cause for the officer to stop and search? Okay. Within minutes, a police officer who had been informed about the robbery and the telephone call observed Dave holding a briefcase at that location. Dave fit the description given by the anonymous caller. An anonymous caller is not so reliable. What makes it worse here is that the robbery is at 1 p.m. and at 3:30 p.m., so 2.5 hours later, some anonymous caller calls in and says, hey, the guy standing on the corner is the bank robber, essentially. Okay. The officer approached Dave with his service revolver drawn but pointed at the ground. Analyze whether he's in custody at that moment. He explained the reason for his approach, handcuffed Dave, now he's in custody, and opened the briefcase. The briefcase contained only the marked currency taken in the bank robbery. The whole issue in these facts is whether the officer had probable cause. So I need to know what it takes to have probable cause. And that's what I'm going to be analyzing. And I think this one's a close call, but we'll come to it later. The officer said to Dave, "I know you're the one who robbed the bank." So is that an interrogation? Where's the shotgun? Yeah, that goes to whether there's an interrogation here. Dave then pointed to a nearby trash container in which he had concealed the shotgun, saying, "I knew all along that I'd be caught." So that's Dave's statement to the officer. That's call 3. We know that when you put something in a trash container, you have abandoned it. And so you no longer have any reasonable expectation of privacy in it. That shotgun is call 4. So I need to analyze that, but I also need to analyze more in call 4. Yeah, Dave was charged with robbery. He's chosen not to testify at trial. And as we already read, he's moved to be allowed to read aloud a newspaper article, call 1, to be selected by the judge without being sworn as a witness or subjected to cross-examination in order to demonstrate that he has no accent. He has also moved to exclude from evidence the money found in the briefcase. That's call 2. His statement to the officer, call 3. And the shotgun, call 4. So we already said call 1 is about what can a witness do and what's required of a witness. To be a witness, you have to be competent and you have to take an oath to be truthful. Dave is trying to get around that. He's trying to, in essence, testify without being under oath and without being cross-examined. It's not going to work, as I said earlier. The currency, that's about Fourth Amendment search and seizure. Dave's statement to the officer, that is about the Fifth Amendment, about custodial interrogation, and that's going to be a reasonably long analysis as well. Call 2 and call 3 are pretty long analyses. Call 4, about the shotgun, that is going to be centered around fruits of the poisonous tree, I think, because it's questionable whether there was probable cause for the officer to take him into custody in the first place. If you find no probable cause, then the evidence that came from that is going to be fruit of the poisonous tree. And so that's what I think my analysis on call 4 is going to be. So far, call 1 is the short call. I've already talked about that quite a bit. Move on to call 2, about the currency. To do a Fourth Amendment analysis, you have to give a legal premise. You have to give a general rule, like the Fourth Amendment applicable to the states via the 14th protects against unreasonable searches and seizures of persons and property. Warrantless searches are per se unreasonable, absent an exception. And then you have to, before you move on, establish standing. To establish standing, you have to establish that the defendant had a reasonable expectation of privacy in the things searched. So here, it was a briefcase. Do you have a reasonable expectation of privacy in a closed briefcase? I would say yes, you do, just like you do in a purse. So then move on to the exceptions. The big exception staring you in the face is search incident to lawful arrest. So do we have a lawful arrest here? Do we have, in particular, probable cause? That means specific facts that go to a particular person committing a particular crime. This officer knew about the bank robbery, but are there enough facts, reliable facts, to give this officer a reasonable belief that this particular man committed the bank robbery? And I think you have trouble with that because of it being an anonymous caller. And what the caller has said is he has a sawed-off shotgun in the briefcase. How in the world would he know that? 2.5 hours later, how would he know that that guy has a sawed-off shotgun in the briefcase? And is it unusual to see a man standing on the corner in the downtown area holding a briefcase? I doubt it, because most courthouses are down there, and virtually every attorney that goes into the courthouse goes in carrying a briefcase. So I think your probable cause analysis is difficult. The conclusion I would reach is that if you find probable cause, then this search could be justified as a search incident to lawful arrest. If you do not find probable cause, then this search is not justified. Now, on call 3, Dave's statement to the officer, that's a Fifth Amendment Miranda issue. It hinges on whether there's a custodial interrogation. Was Dave in custody right off the bat with the drawn revolver pointed at the ground? That's arguable. But at the point that the police officer handcuffs him, he's definitely in custody. Is there an interrogation? Well, yeah, when the officer said, "I know you're the one who robbed the bank, where's the shotgun?" he should have known that that could elicit an incriminating statement. So I think there's custodial interrogation here and no Miranda rights. Does that mean that the statement will be excluded? Well, there's an exception, public safety doctrine. So I think that the public safety doctrine is going to bring this statement in. On the shotgun, the defendant pointed. Was that testimonial? Probably. It was assertive and it was communicative. The big issue here, as I said, is fruits of the poisonous tree doctrine. If there was no lawful arrest, then fruit of the poisonous tree doctrine would apply and would keep this out. But there are exceptions. There's no fruit of the poisonous tree doctrine under Miranda. If the police would have searched for evidence and would have found it anyway, that's the heart of inevitable discovery. The third way out is that the defendant doesn't have standing because there was no reasonable expectation of privacy. He threw that gun in the garbage. And the fourth is plain view doctrine. All of that needed to be analyzed. Okay, as usual, this is a racehorse. It's difficult to finish any of these bar questions in 1 hour. But on this one, when I'm allocating my time, I'm going to need more time for calls 2 and 3 than I am for call 1 or call 4. So I'm going to try to allocate my 45 minutes of writing time that way, because as I keep saying, it takes me 15 minutes to work my way through the hypothetical, figure out what the issues are that I need to cover in these calls. I have 45 minutes left to write, and I'm not going to give each of these calls equal time. Call 2 and call 3 are longer for me. This is a fairly standard criminal procedure hypothetical. The only slight twist is that attempt by the defendant to get to read any passage the judge chooses in court without being sworn in under oath. And so it was a bit tricky to realize that what they were asking you was what's required of a witness. Can they take the stand without being under oath? In other words, essentially assert the Fifth Amendment in a blanket kind of a way, refuse to testify, but still get to read this passage and in essence say, I don't have an accent, so I'm not the guy. And of course, they don't. If you've spotted more issues than I've discussed, that's terrific. I think the issues I've discussed are the ones you really had to write up in order to thoroughly answer this question and score well on it. And if this issue spotting exercise has helped you, if it's been useful to you, as I always ask, please share it with friends, and also please subscribe to our channel. Help us get the word out by helping us with the YouTube algorithm. It helps if you like the video. If you care to comment, do that as well. And we'll see you in the next one.